So we're going to discuss some overarching legal considerations between the bankruptcy code and the environmental statutes. And this is really the place to start because there's a natural conflict between the bankruptcy code and applicable environmental laws. Environmental laws, on the one hand, are designed to protect the public health and the safety by providing for liability and compensation, and to really protect the health of the environment and the people by ensuring that polluters are held accountable and pay for cleanups. The bankruptcy code, on the other hand, has a number of primary purposes, but really for the purposes of our conversation, the main one is to preserve assets for equitable distribution. And so this conflict really comes to head because bankruptcy courts for many years were really ill-adapted to interpret and apply the legislative intent with the environmental statutes while also working within the confines of the bankruptcy code. Environmental statutes provide for strict and retroactive liability, and though that's not all of them, the main one, CERCLA, certainly provides for that kind of liability scheme. And the bankruptcy code wants debtors to have a fresh start. The environmental statutes provide for state and police powers to really empower the municipalities and state governments and obviously the federal government to reach deep into corporate histories and corporate coffers to really enforce cleanups. And the bankruptcy code will allow entities to sometimes leave contaminated sites or walk away from obligations, pennies on the dollar, depending on where their financial stance is. So there's really is a natural conflict between both the bankruptcy code and the environmental statutes.